Hello and welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss important weekly legal news from 28th November to 3rd December 2022. In first important news, the Supreme Court has held that criminal proceedings can be quashed when FIR does not disclose any participation of the accused in the crime. In the case of Ramesh Chandragupta versus State of Uttar Pradesh, the Supreme Court has held that criminal proceedings can be quashed when the complaint on the basis of which FIR was registered does not disclose any act of the accused or their participation in the commission of crime. The court has held that complaint on the basis of which FIR came to be registered, if it does not disclose any act of the accused, deserves to be quashed. In second important news, the Supreme Court has held that appointment cannot be denied merely because candidate was tried for an offence under Section 498A of IPC if he was acquitted. In the case of Pramod Singh Kirar versus State of Madhya Pradesh, the Supreme Court has held that appointment of candidate whose candidature was rejected on the ground that he was tried for the offence under Section 498A of IPC is incorrect and directed appointment of this candidate because the court held that rejection of candidature on the ground that he was tried but not convicted is not correct. In third important news, the Supreme Court has held that existence of an alternative remedy does not exclude the writ jurisdiction of High Court. In the case of Maharashtra State Board of Waqf versus Sheikh Yusuf Bhai Chawla, the court has held that a constitutional remedy cannot be barred or excluded, as when the High Court exercises its power under Article 226, it cannot be a case of lack of inherent jurisdiction. The court has further held that while it may be true that a statute may provide for an alternative forum to which the High Court may relegate the party in an appropriate case, the existence of an alternate remedy by itself cannot exclude the jurisdiction of the High Court under the Constitution. Lastly, the Supreme Court has held that demand of excessive amount of security or bond is impermissible under Chapter 8 of CrPC. In the case of Istkar versus State of Uttar Pradesh, the Supreme Court has held that the provisions of Chapter 8 of CrPC are merely preventive in nature and are not to be used as a vehicle for punishment. The court has held that the demand of excessive and arbitrary amount of security or bond is impermissible as it goes against the spirit of Chapter 8 of the CrPC. With this, we have come to the end of our weekly legal update. If you like this video, please like and share and subscribe to our YouTube channel.